A very good morning, everybody, and a very warm welcome to you all. Let me start by saying that this is the fifth in our series of webinars. I hope you've been able to join us for the previous four. And I hope this finds you well, COVID-free, which is, I think, a challenge at the moment. But today, we are going to focus on an important aspect of the new building safety regime, and that is looking at the gateways, registration and certification process, covering both buildings that are in development, but also those that are complete and legacy buildings, as it were. It's worth, I suppose, stressing that, and we, I think, do this in all the webinars, that this is a policy that's still in development, and our presentations come with that caveat. Obviously, try to interpret as best we can where the legislation is going to land. For example, the bill is in the House today, Building Safety Bill, at an important stage, at report stage in the House of Lords, and amendments have been tabled to make significant alterations to the bill, for example, to remove the requirements for building safety manager, building safety charge. Although that obviously doesn't negate the fact that a lot of those duties the building safety manager would have performed still will exist, and will be requirements on the accountable person. So both our speakers today will be using slides. We also hope to have time to take some of your questions. As always, the request is try and put your questions in the Q&A function rather than the chat, and we will pick those up there. And as with the others that we've done in the series, the full webinar will be recorded and available after the event, both on the BPF website and our YouTube account. We've also got a couple of polls we'd like to do today. The first of those, if I could ask Michelle to conjure that first one up. We're just trying to get a bit of a feel for our audience and how you're affected by the various sort of gateways. So if we could leave that open for a little while and see what response we get, please tick as many boxes as apply to yourselves. And whilst I'll let you fill that in, let me introduce our two speakers for today. We're firstly going to hear from David Hills. David will be familiar to those that have tuned in before. He is a Senior Director at ARC Workplace Risk. Delighted to be partnering with them on this series, and David will give us a good intro to those gateways and some of the requirements. I'm then particularly delighted to welcome Tim Galloway. Tim is a Deputy Director at the Health and Safety Executive, who are taking on the function of the Building Safety Regulator, and Tim is going to give the sort of regulator's perspective on those various requirements, and I think more generally try to give you an idea as to how to get prepared for the new regime and duties that building owners and others are going to face. Before going to David, Michelle, could we have a look at the results of the poll? So we've got our work cut out, because we've got everybody is affected, and in large degree, I think, by the various stages. So as I'd expect, we've got developer members going through the design and planning stage, nearly 50%, 46% there. Construction completion stages of the building, 49%. But as I'd also expect, the majority of those tuning in are either owners of buildings that will be built or owners of buildings that already exist, and almost just over 3/4 of you in that boat. Only 9% are not affected at all. So hopefully you've come to the right place this morning. And without further ado, I'm going to first ask Michelle to take down those results, and then ask David to present our first presentation. Over to you, David.
Good morning, everybody. Name is David Hills. I'm a Senior Director at ARC Workplace Risk. I've been asked to look, obviously, at building registration and certification today. And as Ian's just reminded us, we have had some changes or some proposed changes tabled through committee in respect of the bill. So that caveat that Ian quite rightly stated at the very beginning does refer. Okay, so obviously over the past few days we've had these potential changes, so I thought it might be worthwhile just reminding ourselves why the bill is required and what the bill ultimately is trying to achieve. Now, Dame Judith, in her independent review, suggested actually that the system was failing. So what went wrong? Well, first things first, it wasn't just the specification of any cladding system that was wrong on or in respect of the system. In addition, I think it's also important that we recognise the fact that not all buildings are actually unsafe. There's a large number, a significant number of buildings out there that are safe. And I think it's also important that we have to recognise as well that industry has taken stock. We've seen that, certainly in our experience, industry has taken stock. They've sat up, and in our experience, there are a lot more people out there now looking to actually make sure that they actually understand where they are and understand what they've got to do. And also make sure that they're actually continuing to do the good things that they actually have done. But the key issues that she mentioned in her report was firstly that we are ignorant, or we have been in the past. Regulations and guidance was probably not always read by those who really needed to read them. And when they do, probably that guidance was often misunderstood or actually misinterpreted. In addition, she suggested that we were indifferent. There was a primary motivation in the past, not necessarily in delivering buildings and homes that were safe. And also, in addition to that, when people were raising questions or raising concerns, be them during construction or during management, that most often than not, they were ignored. And I think also she suggested that the indifference really and the ambiguity in regulations and guidance really led to people trying to game the system. It's the words that she used. In addition to that, she actually suggested that there was a lack of clarity in respect to the roles, and clearly that has been very clearly dealt with within the bill. We've now got the introduction of the accountable person and the principal accountable persons. Clearly, obviously, the building safety manager may be removed depending upon what happens today, but we'll see how that particular one falls out. And finally, what she suggested as well, that there was inadequate oversight in respect to the regulatory side and poor enforcement. Now, she suggested that all of the above issues help create a cultural problem within the industry, which she suggested, therefore, was really a race to the bottom. But she also suggested that there was insufficient focus on delivering the best quality buildings that were possible in order to ensure that residents were safe and felt safe. So she suggested around about 53 recommendations, a very new principled approach, a very clear model start off with of risk ownership, which I'm going to quickly move on to in a few moments, making sure that there were clear responsibilities for the client, for designers, principal designers, contractors, owners and managers. And it's all about the delivery and maintenance of safe buildings and basically overseen and held to account by the new regulator. We're going to have a new regulatory framework, which obviously is going to be outcomes based, which is really designed to and incentivized to drive the right behaviors. Of course, if those right behaviors aren't there, then we're going to be making sure that the penalties are going to be sufficient to actually drive that and incentivize that behavior. In addition, we're looking to change the way we think of buildings and look at buildings as a system. We discussed this last time when we looked at fire risk assessments and risk assessments, for example, and we're looking at how we can look at layers of protection, and really ask that very simple question: is the building safe? And really consider buildings on a case-by-case basis rather than be very generic about the whole approach. And then finally, the idea is to actually bring in a risk-based approach to regulatory oversight, and really start to think about the numbers of people who are actually affected, and look at proportionality. So that's really where we actually started from, and that's really where the bill was looking to go. Now, clearly, what the government have done is that they've put the bill in front of Parliament. Parliament are actually reviewing it and making changes. But in the meantime, I think it's very clear that what the government have been saying to industry is, look, you've got to get on and do these things. There are substantial changes that are coming, and we cannot wait for the legislative program to catch up. And clearly there are some problems with that, especially with organizations who have spent a significant amount of money and a significant amount of time working on the building safety manager role. We will see if that is going to be an issue. Personally, I don't think it will. The responsibilities are still there. The accountability is still there. And there's going to be a need for competence and support to the accountable persons. So whilst the actual name building safety manager may go, I personally believe the outcome of this is going to be, in fact, you still need some support and some advice. And what the industry has been told is that there's no excuse, you've got to get on. So what does the Act do? Well, as I said, as I've done this before, really it actually provides you with a various number of layers. We've got the regulatory layer, which obviously includes the new regulator, new rules, regulations in respect of CDM, or at least how the Building Act and construction design and management is operated. We've got the accountability layer, which really is focused about the new roles and making sure that the accountable person, principal accountable person, is held to account effectively. We've got the information layer, which talks about the types of information and new requirements. In respect of that, we've also got the technology layer, which is this digital first approach, making sure that the transfer, sharing, holding of information is maintained in the right way. Or whilst not within the bill, there is a certain level of defensibility required. Organizations need to actually defend themselves, and therefore there are methods that they are going to need to do in order to actually achieve that. We've got the competence layer. There is a need certainly, which I don't think we've really focused on sufficiently at the moment, but competence is going to be key in order to deliver the new regime. And then finally, it's the governance layer. So how the bill operates is very much on the basis that it's actually an enabler. It's an enabling bill. And the first part is actually going to be the bill itself, the primary legislation. And ultimately that will be turning from a bill into an act, at which time secondary legislation, which will be delivered by the Secretary of State to Parliament, will allow for the various elements of that bill to be commenced, and will actually therefore start to actually implement the requirements of the bill. And in addition to that, we're going to have approved guidance, which is obviously going to be risk-based guidance, which will therefore be referred to in the regulations. And if any of you have had the opportunity to read some of the draft regulations, you will already see that there are clauses ready there to actually make sure that those approved guidance will be referred to. So that's really how the bill has been structured. That's how the bill is going forward. I want to now transfer our thoughts really to actually the outcomes of the bill. And I know Tim is going to be dealing with outcomes, but I also want to talk about the mechanisms, because we've got these outcomes that we want to achieve, but there are certain mechanisms that the accountable persons and principal accountable persons are going to have to adopt when dealing with the compliance elements within the bill. And obviously, traditionally, I think it's very clear that doesn't matter really what size of the building it was. You know, if it's a 30-meter plus building, an 18-meter building, even an 11-meter building, or buildings under 11 meters, traditionally what we've seen is that designers have designed, builders have built. We've got people who are involved in fire safety focusing very much on fire safety. We've got general safety practitioners focusing very clearly on their particular parts, each of them operating in their own bubble, including those who are maintaining the building and also managing the building. And each of those are trying to actually tick their own boxes, operating, as I said, in these silos. What the bill is trying to achieve, what the outcome of this bill is to actually move us away from this siloed effect to a much more holistic approach, to actually turn around and say to ourselves, very simply, is this building safe? So the outcome of the bill, as far as we're concerned, and it's going to be interesting to actually see if Tim agrees with us in here, is that that's what we're looking for. Is this building safe? Now, there is a lot that people are already doing that will support that particular claim. So the first thing that we've got to start thinking about is what we talked about last time, which is about the assessment of risk. And clearly, assessment of risk is going to be a really, really important element, because this feeds into the actual safety case. And that development of the safety case looks to answer a number of simple questions. First things first, is the building safe? But is it safe now? And is it going to be safe in the future? It's going to start looking at what information and what systems you use and what systems are required to manage both fire and structural safety, with the ability to demonstrate that current and ongoing safety of the building can be assured. In addition, that safety case is going to start to think about how you can prevent issues, how you can control issues, mitigate or reduce the impact of any major accident or incident. And then it's going to start thinking about the proportional steps that you need to take in respect of fire and structural safety to actually make improvements. Now, that sounds relatively simple in practice, but I think a lot of people are actually getting very worried about the safety case, and it's certainly something that we've been working on with our clients to see how we can support them in getting to a position where they can capture that safety case information before they start thinking about that safety case report. Now, obviously, one of the other elements as well is to actually ensure engagement with all of those concerned. That's the regulator, that's other prescribed persons, and of course, as Dame Judith suggested, the residents have got to start to play a very, very important role in supporting safety within their own buildings. And finally, the wrap around that is, as I said, it's about making sure that you have the right information as well as the technology to support that. So for us, when we look at the pathway to compliance and the pathway to reach that particular outcome, it's about those four main particular areas: assessment of risk, to develop your safety case, to actually ensure engagement, and to make sure that you've had the opportunity to get the right information to support the whole process and to deliver that final outcome of ensuring that we've got safe buildings. So what are the mechanisms that we have in place? The first mechanism we need to think about is the design and construction side. And I know Tim is going to be dealing with a lot of this, so I'm going to quickly go through this particular part. Now, obviously, the new regime that we've had in place really is aimed on a very simple principle, that the person or the entity who actually creates the building safety risk should, as far as possible, be responsible for managing that risk. And therefore, the client is going to be responsible for both registering and notifying all of the relevant bodies, for making sure that key building information is in place, as well as ensuring that the competence of those persons who are involved in the process is where it should be, or at least making the checks to ensure that it's going to be there. But I want to turn then to the actual gateways themselves. We've got a 3-gateway approach. Now, gateway 1 during the planning phase, and as I said, I don't want to spend too much time on this. Tim will go through this. It's all about making sure that during that planning phase, clients will develop their fire statement which obviously will be provided to the local planning authority, and understand that the regulator is and already is a consultee with the local planning authorities. We've already seen planning authorities asking for that fire statement, so industry has started to deal with the Gateway 1 element. Gateway 2 really deals with building control, the need for clients to register their building with the regulator to ensure that within a set period of time that they actually provide key building information, and the regulations that are out there set out clearly what that key building information needs to look like. There are about 50 elements to that, and that will have to be provided through a technology solution that the regulator will provide. They're going to have to ensure that full plans applications are submitted and that they are approved prior to commencing works. Now, one of the areas that I'd like to understand is what does approval mean? Are we talking about a full approval, or will a conditional approval be accepted? And that's going to be something that I would imagine is going to be worked on over the coming months. And then finally, in respect of this, it's Gateway 3. It's all about completing and handing over the building to the owner. There is a requirement for completion certificates before occupation. An occupation, by the way, defined within the bill is where there are 2 or more units occupied, as well as ensuring, by the way, that the golden thread of information relating to how the building was designed and constructed is then handed over to the accountable person, and then obviously clearly made available to the regulator. The issue in respect to completion certificates does raise one very, very clear question, and it's a question that I've been asked in the last couple of weeks more than once, and that is, how do we deal with the issue in respect of phased completions? Now, clearly, I know Tim will probably deal with this, but in our eyes and in our experience, phased completion needs to be considered by the client and the designers, as well as the principal designers and contractors, to ensure that those who are going to be in the building are safe. And that has got to be, during that particular process, the primacy. So certainly I'd be interested to find out how and where this is going, but completion certificates is certainly one area which I think is going to be of interest to those who, in the poll, clearly are actually undertaking planning and development works. So I will let Tim go through the gateway processes a little bit more. I want to focus now on mechanisms for assurance in respect of in-use buildings. Now, the responsibilities and the requirements are on the accountable persons and the principal accountable persons are actually quite significant. They don't look like they're going to be changing too much other than one particular area, which I will deal with. But first things first, you've got to, as an accountable person, you've got to receive information. Now, you're going to be receiving information from either the client, the designers and contractors, etc., if it's a new build, or if it's an existing build, then there'll be a requirement to receive information from the principal accountable person and accountable persons. So the first thing that you're going to have to do as a principal or as an accountable person is to actually register the high-rise building with the regulator. And again, regulation will be in place to actually determine how that is undertaken. And of course, there will be fees that will be payable as well. You have to take the information that you've received. You've got to validate that information. It's very clear that you can't just accept the fact that you've been given some as-built plans and as-built details. They've got to be validated. You've got to be assured that you've got the right information. You've got to store that information and then make that information available to the relevant parties. And obviously that's known, as we all know, called the golden thread. You've then got to provide mandatory or prescribed information to the regulator during that registration process. and that prescribed information will be detailed within new regulation. You have got to prepare your safety case and your safety case report, which I know that we're going to be dealing with probably at a future seminar, but certainly that's one of the areas that you're going to have to do. You're going to have to undertake a new fire and safety risk assessment, and then ensure that you manage those risks. And that's one of the important parts. It's not just about undertaking that assessment, it's managing those risks that stem from that assessment promptly is how the bill is looking and how it's dealing with it. You've got to actually undertake or develop a mandatory occurrence reporting system. And that effectively is going to be a system that will allow you to deal with complaints and issues and manage those and ensure that the relevant parties involved have access to that information. In addition to that, you are going to have to look at how you are managing the building. So there are going to be basic building safety management arrangements and requirements that you're going to have in place. And then finally, you're going to have to develop a residents engagement strategy. I say finally, because obviously one of the other areas as well was to ensure that you've got yourself your building safety manager. If, as we believe is going to happen, we know that, as I say, that they've been tabled, it's more than likely that that building safety manager role is not going to be there. But the requirements to manage safety are still going to be there. The requirements to validate all of these documents and make sure that they are up to date, that they are correct, and that they are delivering that safety for the residents and for the occupants is going to be vital. Now, one of the things that have changed from the initial draft was the fact that initially all HRBs, high-risk buildings, were going to have to apply for a building assessment certificate. What we've actually now got is the fact that within the bill, you will be directed by the regulator if the regulator wants you to apply for a building assessment certificate. Now, the regulator will therefore require certain information, and I'd like to go through that on my next slide. But if they provide you with a certificate at the end of the day, that certificate has got to be displayed in a conspicuous location, along with details of the accountable persons for that particular building. So as you can see, the actual mechanisms that are in place are actually quite significant, and there's a lot of work that needs to be done. A lot of this work already is in place within many organizations. I think what there is now need to be is consideration of bringing these all together into a coherent system to ensure and assure safety within existing buildings. Finally, then, I want to quickly talk about the actual registration and certification arrangements and the mechanics around that. What effectively we've got is we've got principal accountable persons and we've got regulators. Now, either before occupation, if it's a new build, or if it's existing build, then immediately at the time of when the regulations are commenced, there will be a requirement for you, as I said, to register the high-risk building with the regulator. And along with that, you will have to provide information and documents that will be prescribed. Now, they will be prescribed via regulation. We do not know what that regulation looks like at the moment. If the building is directed by the regulator to actually apply for a building assessment certificate, then you have got to provide within 28 days a significant amount of information that you should already have as an accountable person, including your most recent safety case report. And I say most recent safety case report, certainly the guidance that's offered at the moment is that it's very clear that a safety case report is not going to be a static document. It's a dynamic document that moves as your fire risks are considered, moves as ownership changes, moves as the building gets changed as well. You've got to provide mandatory occurrence reporting details to the regulator. You've got to provide a copy of your residents' engagement strategy. And in addition to that, under Section 93, you've got to provide what we call prescribed information. And that prescribed information, as I said, will be prescribed under regulation. And sitting clearly outside of that at the moment, initially there was going to be a need to provide the building safety manager details specifically about their appointment. And there was going to be the option for the regulator to consider the competence of that particular person. Clearly, if everything goes through as we believe it will today, then that building safety manager role will most likely not be included. So that's really the registration and certification mechanics. It doesn't deal with the outcomes, it deals with what you've got to do in order to achieve compliance. So probably best now if I just stop and I hand over to Tim to take you through his presentation. Tim.
Thank you, David, and good morning, everyone. Thanks for the opportunity to come and speak to you this morning. I'm going to run through about 10 slides or so. I'll dwell on one or two, but I won't read out every line in every slide, you'll be pleased to know. What I want to cover are the overview of HSE, because some organisations I'm speaking to may not be that familiar with us. I'll dwell on the overview of the proposed regime, and I'll speak about how duty holders, by that I mean organisations with duties under the new legislation, can start to prepare. Next slide, please. So a little bit of an overview of ourselves. We are the occupational health and safety regulator in Great Britain, England, Scotland and Wales. The legislation that David and I are describing applies to England. There may be some crossover into Wales that's being discussed with the Welsh Government. Scotland has its own approach. So everything I'm about to say to you is related to England in the main. But we cover the Great Britain, we cover those three countries. We share our health and safety enforcement responsibilities with local authorities. They deal with workplaces that tend to be lower risk. Shops, retail premises. We tend to deal with those that are high risk, construction, factories, etc. We've got over 45 years experience as an organisation, and I would say that we have international renown as evidence-led and proportionate. We're an organisation of about 2,500 people across the range of disciplines you can see there. That final bullet, I just want to pause on. We explored in the health and safety regime many years ago the question as to whether the regulator could do it all. And at that point, in the early 2000s, we coined the phrase the health and safety system. It's made up of all the organisations and stakeholders, etc., that operate and contribute to health and safety in Great Britain, because it became clear that the HC couldn't do everything. Translating that over to the building environment, the building safety environment, I've started to talk about the building safety system. All the organisations that are involved in delivering, as David said, buildings that are safe. I want you to keep that in mind as we go through this presentation, because I think it's only through the building safety system, and I'd echo David's comments here, coming together to build safer buildings that we will end up with good outcomes at the end of it. If we simply rely on regulators and regulation, I don't think we'll get there. Next slide, please. So our aims are that we have a robust regime that is evidence-led, that there's an independence about the risk assurance, that there's competence among the industry and some of the regulators, the building control profession. And we want to re-establish confidence in the system. I think that's key in terms of our aims, but it's another area where the building safety system has to come into play, re-establishing confidence. Next slide, please. Now, what I've just illustrated on that previous slide was what I call the three pillars: the high risk or high rise or tall buildings, HRBs, competence, and oversight of the whole built environment. Inevitably, the main focus of most of the discussion has been on HRBs, and that's where I'm going to focus because I recognise that that is probably the area of most interest to you. But as I go through, please do bear in mind that some of the things I'm talking about, including some of the things on the slide in front of you, apply to the whole built environment. It doesn't matter whether it's 18 metres or more. It could be 11 to 18, could be less than 11. The duties, for example, in that top row on client, principal designer, they will apply, whatever the building. When we do come into the 18 metres plus 7 stories or more, the BSR, the Building Safety Regulator, HSE, will be the building control authority and will use multidisciplinary teams to execute much of its work, drawing in the expertise of the local fire service and building control to help us come to our decisions about whether we can allow a building to be occupied, whether we can allow the plans that we have in front of us to go forward into construction. And that's where the key points in the process, gateways 1 to 3, come in. And they move from a situation now where you can start construction without plans approval to a situation where it'll be a hard stop. You cannot start to build unless you have approval at gateway 2, and you cannot occupy unless you have the completion certificate, which will be now gateway 3, in buildings of 7 stories or more. The other things to illustrate there is the difference between design and construction and in occupation. These are two different but linked aspects of the regime. Design and construction is effectively a building control function, and it has certain elements that you'll be familiar with now, but those differences I've just illustrated. In occupation, the focus of the BSR will be very much on structural failure and spread of fire. Those are the key duties on the accountable person to prevent or mitigate the risk of structural failure or spread of fire. It will be underpinned by a safety case approach, which has worked very well in major hazard industries and is being translated into buildings, which are more stable environments, yes, but still have that major accident hazard element, as we saw, unfortunately, at Grenfell. Next slide, please. I'll pause briefly on this slide. This is work in progress, and I have to emphasize that this is work in progress. But it does seek to give you an illustration as to how the building control process, the design and construction phase, will work, moving from design through construction and completion to registration. You'll see the words PGO there, that's Planning Gateway 1. That already is in place. And new HRBs at planning stage, when they submit for a local planning authority approval, the local planning authority sends documents to us, the fire statement, for our scrutiny as a statutory consultee, and we provide advice back to the local authority. It's been in place about 6 months. Our early experience is that we are seeing a number of designs that are coming through where the fire statements don't give us assurance. They don't give us assurance that a fire can be fought. They don't give us assurance that firefighters will be able to access the building and emerge safely, possibly with casualties or people they've rescued. I'm not going to go into numbers, but it is a significant proportion of designs that we are seeing that are not, that we're not comfortable with. We have to go back and say we have serious concerns about this design. And that has started to give me concern about the building safety system. Moving on from PGO, once your building has that planning approval, you would submit plans to the building safety regulator. We will form a multidisciplinary team of building control and fire and rescue services, and we'll scrutinise your plans. You will not be able to proceed to construction until you have approval from us at Gateway 2. So there is a difference between how things work now. This is about HRBs 7 stories and above, 18 metres and above. Below that, the system as is continues. You will then move through construction. There will need to be management of change through that process, supplementing different materials, different designs. That will need to be properly managed through change. And we as the BSR, working with our colleagues, will pick moments when we actually come to site to inspect works, probably the moments where there are the key risks to building safety or other standards such as acoustic security, etc. Your obligations on occupational health and safety remain. By the way, you will still have to provide a safe construction site to protect members of the public passing by, people who are working on the site. When that construction is completed, we then move into Gateway 3, the completion certificate, where again, you will have to apply to the BSR. We will probably continue with the same multidisciplinary team if we can, to look at that building and say, is this building safe to be occupied? Does it meet relevant standards? And upon that, you get your completion certificate. And then you can move into the process of registering that new building. Next slide, please. Once the building is occupied, we flip into the safety case aspect of the regime. I want to emphasize some things here. First of all, safety cases is not the case of simply drawing together every piece of information you ever had about the building and bunging it in a box and saying, that's my safety case right there. It's about critical examination of the information you have. And it's enabling you to identify whether you've taken all reasonable steps to make sure the building is safe. Have you done enough to prevent, control, and mitigate the risk of structural failure or the risk of spread of fire? What you will send to us when we ask you to is what's known as a safety case report. That condenses your argument, that critical analysis you've done, into something where you seek to provide an argument, a statement, and you demonstrate where the evidence that supports that argument can be found. Just clarifying something, all HRBs will at some point be called in by the regulator. We will need to decide how we deal with large clients who may have 200, 300, 400 buildings, but all safety cases at some point will receive scrutiny across what I call a regulatory cycle, which currently we feel will be about 5 years. There are some 13,000 buildings out there of various sorts currently, plus new stock that will be added. So there's a certain time period that will be required before we get to the last building and then start the process again. But the safety case report, the safety case is not for me as a regulator. It is not a document you produce for me, put it on a shelf until I ask for it. The safety case is your management system, how you're going to keep that building safe from spread of fire and structural failure. It is, as we've said for many years on the occupational health and safety side of our work, your management system for you to own and run and update and keep alive. And I want to emphasize that because it's going to be, I think, an improvement for some organizations on how they run and operate buildings. And I'll come back to that when I talk about how you can prepare in a moment. Just to pause before I move on to the next slide, there is material that's on our website, 2 documents with further documents to come, hopefully in the very near future, that are there to try and help organizations navigate what is, I know, a very new process in building safety. And I encourage you to look at those documents. They start with the principles document we published last year. There's now what we call a headline document, which went onto our website recently, and a further 5 documents will be issued, hopefully before the end of this month, though that might be a bit tight now. It probably will slip into April. Next slide, please. So in terms of what you can do to prepare, under construction or refurbishment, and that's important to note where we've got major refurbishment, they may end up going through the gateway process too. Consider the life cycle of the building. Consider it as a system, not just a physical asset, but a system, almost a living, breathing thing. And consider its intended use. How will the residents, the students, whomever lives there, interact with that building? I personally was drawn from major accident hazards. I have some experience in human factors. And the general rule of human factors is if you make things easy for people, they'll do it. So if you have certain aspects of that building that rely on residents behaving in a certain way, we'll make it easy for them to behave in that way, because then they're more likely to do it, is the principle I would suggest you might want to think about. How can CDM principles help? That cooperation and coordination that laid out in the occupational health and safety sphere is being translated into building safety. The idea that the client, the designer, the main contractor, the subcontractors cooperate with each other, for instance. And it's important that you understand the supply chain competence that you have and the workers. Will they be able to build you a building that complies with the standards you're expecting? Do they have the right behavior, knowledge, skills, and experience? And I would encourage you to look at managing risks holistically. Build safe buildings safely means thinking about this in concert with the approach to occupational health and safety. Don't end up building a safe building, but killing people along the way. Don't build that building safely, but leave risks inherent into it that might come and haunt residents subsequently. Next slide, please. If you are in an existing building, and I know a great many of you do have existing buildings, if you haven't already, start to collect the information you need to demonstrate the approach to management and control of risk. Think now about your structural and fire spread risks. How are these currently managed? Is there more that might need to be done? Are those people you've got working in safety critical roles competent? Do they have the right skills, knowledge, experience, and behaviours? The time is now to act if they're done, and that's me suggesting that their skills, knowledge, and experience can be improved or brought up, or they're augmented in some way. You don't necessarily have to have one person with all the skills, knowledge, and experience. It can be spread among multiple people. It can be spread among multiple departments. You know your business, you know how it's managed. But I would echo David's comments that there needs to be that coordination and that cohesion about your arrangements, if it's not there already. I'd encourage you as well to review your resident engagement strategies. They might have served you well for many years, but the time might be now to pause and think, are they still fit for purpose? I think that's my next slide is my last slide, which is just encouraging you to keep up to date. We have a newsletter that we're publishing fairly regularly. I'd encourage you to subscribe to that, because that's where you'll get the first new pieces of information that we're putting into the public domain. Our next key pieces of information are 5 documents that discuss safety cases in more detail. So I'd encourage you to keep an eye out for those. And that is me done. Thank you.
Thank you very much, both of you, for very detailed and insightful presentations. I think we've got 12 minutes or so, so I'm going to go a bit of a canter. Firstly, if I could ask Michelle to post our second poll, and we can get the audience to be completing that as we tackle some of the questions that have been coming through. So I've got, I had 3, I think I've got 4 questions now, one in the chat also, and a couple, I think, from myself as well. So just answering the question in the chat, when will the bill get royal assent? My understanding is that we have a Queen's speech on the 10th of May now, so the bill should get royal assent in the next month, but it will have a phased introduction, and there is a transition plan on the DLUC website that sort of sets out the department's sort of best estimate of when certain things will take effect. Go on to the DLUC website, and that'll give you a better idea of that introduction. But the bill itself should be passed by the end of April. A first question from the Q&A was, I think from Bernard. We'll take that one first, which was around air tightness, and whether there are sort of any requirements in the bill that are going to require landlords to owners to check their buildings for air tightness, for infiltration of oxygen. Who wants to take that one?
I'm happy to. No, there's nothing in the bill in respect of that. What the bill requires you to do is to consider, as Tim's just taken us through, fire safety and structural safety as a much more holistic approach. So if air tightness has an impact on that side of it, then you will deal with it within your safety case and within your assessment of risks. But is there anything specific within the bill? No, certainly not at the moment anyway.
And then this also spins out into a question from me, which is, putting your safety case together. I've never been quite sure in my own mind. Is this just fire, or are you trying to take account of other building safety risks in your communications with the regulator? If flood, for example, impact that will have on occupation and structural integrity of the building, or is it just fire?
The definition of building risk is in the bill, and at the moment it is fire and structural safety. But it does actually allow the Secretary of State by regulation to extend that out into other areas. Clearly, when you're looking at fire safety, if you're just going to look at fire safety, again, not holistically, so very myopically, then there will be a major issue there, because there are other safety issues, I would suggest, that that have an impact. Electrical safety, gas safety, all of those have an impact, I would suggest, on fire, and I would suggest in some of those instances, pressure systems, on structural safety. So I think it's very clear for me anyway that a safety case has got to look far beyond the fire and structural side, if traditionally anyway, and look at other areas, because those other areas may have an impact on the safety elements in respect of proving that that building is safe. Tim, I welcome your comments on that.
Well, in terms of what the bill requires, and thus what I can require as a regulator, it's the spread of fire and structural failure. If, as part of your argument in your safety case, you are saying my building is safe because, then I'm going to be interested in the end of that sentence. What is the because, and how have you evidenced it? So it may be that it does go wider in the way that David describes, because that is an essential part of your articulation as to why, on the basis of a critical examination of the wrap around your building, the safety management system around your building, you need to say, well, the main risk of failure for my building is structural failure because of a significant flood, and it undermines the foundations. And therefore, the action I've taken to prevent that significant flood is X, Y, and Z. That's why I am arguing that my building is safe. That's part of your articulation of how you prevent structural failure. I'm not going to start quizzing you on your plans to manage Legionella or asbestos or other things like that, unless they are part of that critical examination that you're doing on structural failure or spread of fire. That doesn't mean that you don't need to worry about asbestos or Legionella or any of those other things. Those continue in place. The safety case regime, the building safety bill, is around and on top of those legal requirements under other specific legislation, including the fire safety order, will continue.
Thank you. Can I ask Michelle to take the poll down, but we'll keep the results till the end, if that's okay. And an anonymous question that came through that I think will be on the lips of many of those that have tuned in is, how will the new regime work where you are have a building that is started before the bill is passed, but completed after it. So you may have gone through the building control stage, but the building's not complete. Are you still then going to have to go through Gateway 3, even though the building started before the bill?
Transitional provisions have yet to be fully worked through. We have been encouraging everybody, to a certain extent, to do what they always ought to have been doing, which is design buildings that actually meet the required standards. Because at some point, buildings will be drawn into this process. Because unfortunately, there are organizations and people out there who will try and game the system. And we want to try and prevent that. So if you go through the process of designing a building and building a building that meets the standards it ought, and it then is pulled in at some point into Gateway 3, you shouldn't have any problems, because it will pass Gateway 3, because it's been built to appropriate standards. If you are wanting to try and dodge the system because you want to try and not build a building that meets appropriate standards, then I do want you drawn into that system, because I don't want your building getting through to the point where it's occupied, for obvious reasons.
Thanks, Tim. I'm conscious that Jeff from Alman Cantor had asked the question long before anybody else, and so I feel we should take that one next, which is around PAT testing and extent to which the Grenfell tragedy was sadly caused by a faulty fridge, and have the HSE given any consideration as to sort of making PAT testing more compulsory in a leasehold situation, either by the landlord or entry by the landlord to do those tests in people's flats?
There's no plans to require PAT testing on the part of residents. What conditions are applicable and appropriate in lease, I believe, is part of property law, and I'm not sure whether freeholders would be in a position to demand that residents provide PAT testing certificates or things such as that. There may be some property lawyers on the call who are better placed than I, but there's certainly no plans on the part of government to start demanding PAT testing on the part of residents. You can see how that might play once Grenfell is a generation behind us and memories of those terrible events are starting to fade. It will flip from a good thing that ought to be done into building safety gone mad, which is a tagline that we in the HSE used to have to deal with. I don't want this regime to go into that kind of area, and forcing residents to do PAT testing, I do wonder if that might actually start to turn people against the regime, which will then start to undermine the very thing we're trying to achieve. Notwithstanding the fact that people should buy and keep electrical gear in good standards. It's what I do in my own home because I don't want my home burning down.
Thanks, Tim. David, we'd in our sort of preparations for today, we'd talked about phased building delivery and how the regime works in those circumstances. We've got members who are developing things like student accommodation, which will arrive in stages. How does the regime work in those circumstances?
I think it's worthwhile saying again that those arrangements, I understand from talking to Tim, are being discussed and being arranged. Certainly, though, I think the concept has got to be about the fact that if you're going to go through a phased completion approach, then we've got to make sure that the people who are going into that building are going into a safe building. It's got to be safe for them to occupy. So whatever process that is going to come out of the new regime, I would imagine, as an ex-building control officer, I would imagine that that's exactly what they've got to start to think about. How do we actually ensure that that building is safe in its current use, even if that building is not complete? I would welcome Tim's comments on that as well.
David's right. There is an ongoing discussion as to if and how stage completion, partial completion can go forward. There is obviously the questions around whether that is a significant amount of risk that you're putting into the system there, because you've got ongoing construction works, potential hot works, all kinds of things that can start a fire, and then a building which has got people in it nearby or as part of that development. Balancing that against, of course, some of the models for developing and building, some of the business models are based around stage completion and release of units to sale to fund other parts of the development. I acknowledge that, but it is an ongoing conversation.
Thank you, gents. We unfortunately at our closing time of 10 o'clock. My apologies that I've not been able to get through everybody's questions. Perhaps Michelle could just bring up the results of the second poll, which is a sort of a bit of a bell curve, really. We'd asked people how satisfied they were with their preparations for the bill, and The biggest scorer moderately satisfied at 38%, with about 22% that feel they are very or very sorry, 13% at I'm looking at the wrong bell curve because we've got a small 9% who are not affected, of course. So it's a little bit more actually upbeat than that. There's 51% that are very satisfied or moderately satisfied, 27% neither satisfied or dissatisfied, and 13% that are moderately dissatisfied or very dissatisfied. So hopefully today's webinar will push those numbers towards the top of that rating a little bit more. We are planning a 6th in the series, and look out for details of that. It only leaves me, I think, to say a huge thank you to Tim and to David for taking time out of their day to give us 2 excellent presentations, and really grateful for you for doing that. Please use all the resources that people are sort of pointed to during the presentations. And as I say, the webinar will be recorded and will go up on our site and YouTube account after the event if you want to look back on anything. So thank you very much for all your participations today, and again a virtual clap for Tim and to David for giving us their insight. Most appreciated. Thank you.